take a little over an hour. Today's speaker is Ed Foulke from Fisher Phillips. If you have any questions, please enter them into the question box and he will get to them at the end of the webinar. If you would like to watch any more webinars, please go to hrsimple.com/events and you will see a listing of webinars from Fisher Phillips and other reliable sources. Ed is also author of our Workplace Safety and Health Compliance Manual, one of our federal book resources. And for attending today, we are giving away a free digital copy. You will get the instructions for the download along with the slides, a recording, and the Sherman HRCI credits after the webinar. If you did want to check out any of our other resources, you can go to hrsimple.com/shop. Ed is the only attorney in the country confirmed by the U.S. Senate to run the Occupational Safety and Health Administration. He is currently a partner in the Atlanta office and the Washington, D.C. Metro office located in Virginia. He is the former co-chair of the firm's Workplace Safety and Catastrophe Management Practice Group and is also the president of Fisher Phillips Safety Solutions. Prior to joining Fisher, Ed was the Assistant Secretary of Labor for Occupational Safety and Health, named by President George W. Bush. He served from April 2006 to November 2008. During his tenure at OSHA, workplace injury, illness, and fatality rates dropped to their lowest levels in recorded history. So now that we've learned a little bit about Ed, I'm going to go ahead and pass things over to him so we can go ahead and get started.
Thank you, Anna. I guess I got to click on this here. Okay. And welcome, everybody. Good morning or good afternoon, I guess, depending on where you are in the country. I deeply appreciate you being part of this program. And I'm going to just want to kind of start off by just saying thank you for your commitment to safety and health. Obviously, the fact that you're all involved in this program today tells me that you're interested, you care about your employees, you want to know everything, you want to make sure that you're up to date on the things that with respect to safety issues that are involved in your particular operations. And of course, record keeping is very important because it covers pretty much everybody. Now, as we'll see, there are some employees that, because of their size, if you have 10 or less employees, then you're going to be exempt from the reporting. Now, the recording of injuries or illnesses on your 300 logs. However, you are still required to report, as is every employee. If you have one employee, you are required to report any fatalities, hospitalization of employees, amputations, loss of life. And I'll get into much more detail about that, but you need to understand it. But I did want to just say thank you for your commitment because, you know, the safety profession in the past has not really received the recognition I believe that it should receive, because the things that you safety professionals that you put in place, the policies, procedures, the training, all those things allow people to go home safe and sound each and every one to their families and loved ones. And in the past, really, the safety profession just has been kind of almost a second thought, which always bothered me. Even when I was head of OSHA, I tried very hard to try to raise the level of visibility of safety professionals throughout the country, particularly in companies. But so, as I noted here, I put this quote by Vince Lombardi. I saw this and I said, my God, that applies exactly to safety. And he said, winning is not a sometimes thing, it's an all times thing. And so is safety. So we got to be happy. We need to really be committed on that. And, you know, one good thing, if there's any good things that have come out of the pandemic, is the fact that the safety profession is now seen by the upper management, the C-suite, the CEO, CFO, COO, all recognize the importance of safety that they have been involved with respect to the COVID-19 pandemic and the things that have been put in place and them handling that. So I am hopeful that recognition will continue going forward, and that the safety profession will get have more of a seat in the C-suite than they've had in the past. So anyway, why is this going to be important? And one thing I'll mention to you right up front too, you know, I think we're going to, as I understand it, we're going to provide you a copy of the slides, And also, I'm going to make sure I give Anna I have a record-keeping worksheet. And it basically kind of reduces to about 6 pages, everything that we're going to talk about today. And it will help you. You can take that, you can make a new, every time you have a case, you're trying to figure out whether it's recordable or not, then you can use that outline or the worksheet, and you will get it right probably 99% of the time. I can't say 100% of the time because people still make mistakes, and it's really interesting. And so the question is, why is record keeping so important? And I want to let you know this. There is not a week, and sometimes during that week, not a day goes by that I do not get questions about OSHA record keeping. And I do a lot of it, and I've been doing this for a long period of time. Anna didn't tell you when it started, but people ask me, Ed, how did you get started in safety and health? And I told them, well, it was by an accident. But it really was by a fatality. I was at a client's facility in Smyrna, Tennessee. I was there I was 2 years out of law school. This was in 1980. So you can see I'm kind of an old guy, but I do have an 8-year-old daughter. So just take it out. I'm 68 and I have an 8-year-old daughter. So you can figure that one out in your spare time. But I was there to do supervisory training on labor and employment issues. While I was there, the client, this was one of our large clients. It was a construction company. One of its employees was standing halfway up a 6-foot ladder. So he was standing, 3 feet off the ground. 3 feet off the ground. Fell backwards and got killed. Now, I've had 2 cases where employees have been standing halfway up 6-foot ladders, fell backwards and got killed. So what does this tell us? This tells us that people die very easily, and that's why it's so important. So like I say, I've been doing this since 1980. I've been doing it for a long time. I've handled thousands and thousands of OSHA inspections and OSHA contests. I've done about 400 or so OSHA fatality investigations. So, and all I can say is you don't want to ever have a fatality. So that's why I say it's important to what you're doing, because you allow people to go home safe and sound every night to their families and loved ones. That is extremely important. So, but anyway, so we're going to send you those 2 things. But every time we have an OSHA inspection during the opening conference, inevitably, and this is pretty much 99% of the time also, the OSHA inspector will ask to see your OSHA 300 logs and the 300A summaries. Now, if you're exempt, and we'll talk about those companies that are exempt in a second, well, then you're not required to do it. You can say, well, I'm exempt. I got clients that are fast food type of people, the restaurants, those type of things. They are exempt as exempt industries. There's approximately 80 industries that are exempt from doing record keeping. And as I mentioned before, if you have 10 or less employees, you're also exempt from doing the record keeping. You're not exempt. No one is exempt from doing the reporting, calling OSHA and telling them when you have a fatality, hospitalization, amputation, loss of life. So anyway, but so every time I have an OSHA inspection, when I know the OSHA inspector's coming, we have an accident and we've called OSHA, and they call me up and let me know they've had an issue and they're expecting OSHA to come. First thing I'm going to ask them is, why don't you please send me at least the last 3 years? And you got to make sure you have the last 5 years, but let me look at the last 3 years of your 300 logs and 300A summaries, because we're required to give them. And that's one of the things that you are. OSHA is, when OSHA asks for them, you have 4 hours to give the 300 and the 300A summaries to OSHA when they request it. So, but I want to make sure. So, and inevitably, and I don't care if it's a Fortune 200 company or a mom and pop, I'm finding errors in the record keeping by all those groups. So that's why this is so important. But look at how they expanded the definition of recordable. This was done during the Obama administration. Of course, there's better tracking of injuries and illnesses, particularly in industrial hygiene. During the Obama administration also, they expanded the definition of work-related. They limited first aid, the definition of first aid, and they expanded the definition of medical treatment. That was back in I want to say Bush 2, may have been in the Clinton administration. But anyway, so we got a whole group of different people there. So these are why all this is important. And of course, I hope you're aware of this, but OSHA has expanded the average penalty. This was done during the Obama administration. They tied it for the first time since the act was enacted in 1970, OSHA, the Congress attached the penalty amounts, and it wasn't just OSHA, it was MSHA, and it was a bunch of other different standards and such, to attach the cost of living to the penalty amount, so that the penalties will continue to go up each year. Now, back in 2016, I think it was, when they made the change, there was a fairly significant increase in the penalties for all other than serious, willful, and repeat. Each year now, the percentage increase is like 1.5% from the previous year. So, and right now, just to give you an idea, willful and repeat violations are, I think, $126,000, the maximum penalty. So you're still talking a lot of that. So you have those things. And of course, OSHA, I think you're going to see this number 2 bullet. You had it in the Obama administration. I'm sure you're going to see it in the Biden administration, is the use of willful, repeat, and egregious citations much more frequently. Employers that are in multiple locations have a lot of different special issues that they have to deal with from a reporting standpoint. So, and of course, like I said, in January 1st, they expanded in 2015, they expanded the reporting requirements. Now, you always were required under the record-keeping standard to report a work-related fatality. Now, look at that term I just used, work-related fatality. You need to understand that. You've got to make sure it's work-related. If it's work-related and it's a fatality, then you have 8 hours to contact OSHA, all right? 8 hours. Now, you better make sure it's work-related. And I'll just give you a quick example because we got a lot to do, but I want to give an example on this one, on work-relatedness. I had a client that had an employee, a manager. He attended a meeting, a bunch of managers in the conference room at this building, at this office, from 4 to 5. And the meeting ended, and he got up and he told a couple of the colleagues there. He says, I'm not feeling so good. I'm going to go back to my office and just sit down and rest for a little while. Well, that was at 5 o'clock. 8:30 that night, the cleaning staff found him hunched over dead on his desk. And my position was this was not work-related. Yes, it occurred in a work rate, and there's a presumption that it's work-related. If it occurs in work, there's a presumption that it's work-related. Now, during the COVID-19, that presumption was kind of loosened up for a while, but now it's kind of going back. Not totally back, but pretty much back to where it was on the presumption of being work-related. Now, you have, under the OSHA guidance, you as the employer have to demonstrate that, in fact, that it was not work-related, under the presumption, under the old presumption. The presumption was automatically work-related. Now, you can show that it's not work-related, but anyway. So, and then they changed the hospitalization. Before it used to be you had 24 hours, you had 24 hours to contact OSHA if you'd had the hospitalization of 3 or more employees. Well, during the Obama administration, they changed that to 1 employee. And I remember seeing Dr. Michaels. He was my successor as head of OSHA. And as this came out, I just happened to run into him one day right after that. And I said, you better get ready to hold on to get inundated by calls on the hospitalizations of 1, because they changed it from 3 employees to 1 employee, the hospitalization of 1 or more employees. You, for a work-related incident, you are required to contact OSHA within 24 hours. And he said, oh, no, it's not going to happen. I said, just trust me about this. And sure enough, they were inundated by calls because, for an incident to have 3 hospitalizations from 1 incident, that doesn't happen too often. It happens, but it doesn't happen that often. But the hospitalization of 1 employee from a work-related incident, especially now when the hospitals, they're going to take them, bring them in for observation, keep them there overnight. They say it's for observation, but then they give them medicine, and that makes it medical treatment. So now it's hospitalization with medical treatment, so it is reportable. So if you have the hospitalization, inpatient hospitalization, you have to stay overnight, and not for observation or diagnostics, okay? But if it's there, but if they give them if they're giving them medicine, unfortunately, the horse is out of the barn by then. So anyway, With a hospitalization of one or more employees, you have 24 hours to contact OSHA. Same thing with amputations. And the amputation is defined as the loss of a fingertip. No bone loss is necessary. If you lost skin at the top of your finger, even if they replace it back, it's still, you have to call OSHA within 24 hours, okay? And let me tell you something. You call them, if you call them for a fatality, they're coming, okay? They're going to be coming. You need to prepare. If you call them for a hospitalization of one employee, maybe not coming. But if you call them because of hospitalization of two or more employees, they're probably going to show up at your door fairly quickly. If you call them and tell them it's an amputation, they're going to probably show up, okay? Because there's a national emphasis program on amputations, so you need to be aware of all these things. So you can expect it. And if you know you're calling them, and you got 24 hours, get your darn ducks in a row, please. Make sure your logs are ready. Make sure whatever the incident was there something there? Where they got an amputation? Was it caught? They didn't lock out or tag out? Look at your lockout tag out program. Make sure they had the training done. All those things. Let's make sure we have lockout tag out procedure for that particular machinery. What did they do wrong? Now, and particularly if you're going to be doing, let me do yourself a favor on this too, please, 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 please. If you're going to do an accident investigation, which you should, then please get your in-house counsel. And if you're a small company, don't have an in-house counsel, get your the counsel, whatever you deal with. Contact them before you start and have them direct you to do the investigation so it can be brought under the attorney work product privilege, okay? That way OSHA can't get it, okay? Please do that for me, because this is very important. Because unfortunately, when people do investigations, they put stuff in there they should never put in. And always leave it as a draft. Never make it a final thing until you get, because you don't know all the facts. You may not know all the facts for a couple months, okay? Particularly if somebody gets injured and in the hospital and you can't talk to them, there's no way. So you always have that thing stamped at the top. Privilege of confidential attorney work product draft. So that way it's not discoverable by OSHA. So, okay? And then the last one is loss of an eye. Now, I've been doing this for over 30 years, actually a little bit more, pretty much more than that. But anyway, I've never had a loss of an eye. This is a physical loss of an eye. The eye has to physically come out. But if you have that, you got 24 hours to contact us. And of course, once again, of a work-related incident. And we'll talk more about next one on retaliation. And we're also going to talk about electronic filing in a minute. So let's keep going there. Temporary employee initiative. OSHA is very much focused on temporary employees. If you have temporary employees, if you have using a temporary employee provider, let me tell you something. I don't care what they tell you. If they say, listen, part of our services is to do your 300 logs for the people we provide you, that I don't care. Unless they're providing you a supervisor that supervises those people directly, they go on your log. It is your responsibility. Don't buy whatever they're saying. It's a marketing tool. Well, we're going to do this for you, and you won't have to do it. Yeah, well, guess what? If they're doing it and you're not doing it, you're going to get a citation, okay? So please make sure, if you have temporary employees and you are supervising them, they go on your logs, all right? Great. Of course, we still have a lot, like as I mentioned before, I still got clients all the time calling me. They're making mistakes. I mean, and we'll talk about some of them. You got to make sure you don't hear. Many employees are unnecessarily recording first aid instance. We're going to go through every first aid because it's a set number, okay? Either it is or it's not, okay? So you're going to do that. Of course, there's no coordination between workers' comp and OSHA recording. If just because it's a workers' comp does not mean it's going to be an OSHA recordable, okay? Now, if it's an OSHA recordable, it most likely is going to be a workers' comp case, okay? So it doesn't go both ways. And the other problem is that we got people we're doing audits, but not correcting the documents later on. So more and more, and I think you're going to see this more in the Biden administration because it was in the it was in the Obama administration. Obama was looking to tie in. If you had OSHA citations, then that could impact your ability to get government contracts. I suspect that disappeared during the Trump administration, but I think it'll probably come back during the Biden administration. So, and of course, we're having if you're a contractor, supplier, vendor, then there's a good chance more and more companies are hiring ISN or Avetta to do what they're called. Those two companies are basically subcontractor certifiers. they're going to look at your OSHA, they're going to look at your safety and health record, they're going to look at your 300 logs, they're going to look at your overall program, your DART rates, injury and illness rates, all that, and they're going to give you a score. And guess what? If you don't get a high enough score, you're not going to be able to bid on work from some of your contractors that you have already, some of the clients that you have currently. So you need to be aware. This is very important. And the problem is, that's why you want to make sure that you're reporting properly, correctly. If you're putting first aid injuries on your log, your numbers are going to go up, and that's going to bump you out. So that's why all this is so important here. But we need to make sure going forward, we look at our injury and illness reporting policy, make sure we're reviewing our records on a routine basis, and we're correcting logs. You are required under the statute, under the OSHA record-keeping standard, I should say, you are required to update your 300 logs. Now, it doesn't say for 5 years, plus the current year, but it doesn't say anything about the 301s. But, however, if you update your 300 logs, your numbers on those numbers now have changed, and your numbers that you have on the 300-day summary are wrong. And guess what? OSHA will cite you for that. So if you update your 300 logs and you change your numbers, you need to update the corresponding 300-day summaries for that year, okay? And we got to train our people on site as to how to do proper record keeping. And I'm telling you, it's not easy. I mean, it's kind of easy to do it, but you got to really know what you're doing. I do it every day, so I'm familiar with this, and I get asked questions, and sometimes I don't know the right answer. But the good thing is, having been the former head of OSHA, I get the call. I know who's the record keeping guru at OSHA. So I call him up and I say, what do you think about this? And he gives me the answer. And you know what? Even if he's wrong, he's right. His answers are right. So anyway, but it happens all the time. So we want to make sure we're training our people there. And of course, we're using these. The 300s can be used do the accident investigation, root cause analysis, and it can really help your 300 log can assist you in doing your risk analysis. I tell clients, I've always told them, particularly small companies, they say, well, what can I do? I say, how to improve? I say, use your 300 logs. You got the 300 logs, look on those 300 logs. If 55% of your incidents are occurring in Department A, you have a problem in Department A, and you got to go figure what it is and fix it. These logs can be used as a really good safety tool. So, of course, we're going to develop more safety programs. We're going to have to look at our safety incentive programs, and this is going to become more important in the Biden administration. During the Obama administration, they were focusing on improper safety incentives as a way of retaliating, as a retaliation against employees if they reported an injury or an illness. Okay, I suspect they'll be during the Trump administration that was not a big issue. During the Biden administration, I think you're going to see going back to this. So you need to be doing it. We got to stop. We're not going to get away from lagging indicators. We got to get to leading indicators. Lagging indicators is the DART rates, injury and illness rates, those type of things. Those things have already occurred. That's why they call them lagging. You want to do other things that are going to be doing what I call leading indicators. Behavioral, doing safety observations, part of a behavioral-based safety program, preventive maintenance programs, training programs, all these things they're having, those things can all be set up to be leading indicators that can help you improve your safety program. So we're going to keep looking at that. And of course, we've got to be prepared for an OSHA inspection, record-keeping inspection. If they see that our numbers aren't right and they see a lot of errors, they're probably going to open up a record-keeping inspection, and you don't want to get into that because Lord knows they'll be there for several weeks going through your records. So, auditing your process. I mentioned a little bit earlier ago, most companies, well, I shouldn't say most, a lot, some companies can't because one person is doing all these 4 things, but a lot of bigger companies, you got one person doing the OSHA stuff, one person doing first aid FMLA, next person doing workers' comp, and then the others doing short-term and long-term disability. But the problem is if you're doing this OSHA, if you're handling OSHA, doing the logs, you got to know, is this first aid? You need to go out there out of family medical leave. Was it workers' comp? Was it really a workers' comp case or not? Not that it, like I say, it may or may not. That's not a determinant. But anyway, are they on short-term, short-term, or long-term disability? That gives us our numbers for the log. So all these things have to work together. And unfortunately, if you got 4 people doing these, each one doing one of these things, they're probably not talking, and we communicating. We got to make sure we do that better there. So. Well, so you want to make sure you're consolidating all those things into one system so that everybody, particularly the OSHA person, is getting the right information, because he or she, in order to fill out the 300 logs, needs to know how many days away from work, how many restricted work, how many job transfers, whatever it is. Okay? And they need to know those dates, those numbers, how many actual numbers. So anyway. Now you're allowed under the record keeping standard to keep a corporate-wide log, but you might be able to at least, or you can keep it at the corporation. But if somebody asks for that document, asks for a 300, one of the employees asks for the 300 logs, or a representative of 300 or 300 days, you're required to provide that within in the next day. So there's some others that go a little bit longer, but so you need to realize that you need to be able to pull up that information pretty quickly. But let me tell you something. If OSHA has 4 hours to pull it up, so you better be able to pull it up. Okay. So, okay, you're required to also audit your logs for 5 years. You're required to keep your OSHA 300 logs, 300-day summaries, 301s or first report of injury warrants for each one of those entries on the 300 logs for 5 years plus the current year. So make sure, particularly on those 300-day summaries, you know, you put those up on February 1st and they're going to be taking them down the end of this month. When you take them down, don't throw them away. You are required to keep them for 5 years, okay? Please don't throw them away. Unfortunately, I have this all done all the time. They take it down, they don't think they need it anymore, throw it away. So you're required to keep those 300 logs, 300-day summaries, the 301s, or the first report of injury forms, whichever one you're using, for 5 years plus the current year. So, all right, let's keep going, because like I say, we got a lot of slides here, but we're going to get all through all this stuff. State plans, for the most part, they pretty much track the Fed, so I won't get into that there. I think you're going to see probably coming up a focus on musculoskeletal disorders. That was kind of the thing during the Obama administration. I think you'll see it here. And of course, you know, there's a much more union focused here in the Department of Labor, and probably, I suspect, at OSHA. Well, it is to a certain degree. I mean, you got Secretary of Labor Walsh got confirmed last week. You know, very big former union person, mayor of New York, Boston, excuse me. The deputy assistant secretary for OSHA, the number 2 guy at OSHA now is acting as head. He's the he's the political. Once again, heavy union background. And they added a new directorate at OSHA called on COVID-19, who also worked with a lot with the union. So you're going to see a focus on that. And the unions are very much on OSHA, very much focused on enforcement. So I think you're going to see much more of an enforcement bent than we did in the Trump administration. So let's keep going. We got there. Electronic filing. They have not changed this. Well, I should say this. We haven't changed. Back in the Obama administration, they put this electronic filing whistleblower retaliation requirements back in May 2016. And it went into place, but then it was supposed to start in 2017, requiring everybody to do the electronic filing. The Trump administration says, well, we're going to require employers who are required to electronically file the 300-day summaries, but not the 300 logs nor the 301s. All right. So there was a change. They withdrew that to the thing, so I did a Federal Register notice on that. My gut reaction, they haven't changed it yet, so for this year, 2021, you're only going to, and you should have already finished filing it, electronically filing all your 300-day summaries if you're covered. You know, if you have 250 more employees, then you should have been electronically filing your, unless you're exempt. You should have been filing your 300-day summaries. If you have 20 to 249 employees and you're in certain industries, particularly like manufacturing, construction, then you should have electronically filed your 300-day summaries. I suspect if I had to bet money on this in the next year or so, you will see them go back to the, withdraw what the Trump administration did and put in what was in the Obama administration, start requiring all employers to electronically file their not only the 300 days, but also the 300 logs and 301 supporting data. So, but we'll just have to wait and see on that one there. You are required under the standard to inform every employee how to report an injury and illness, and you got to set it up in such a way that that they don't feel like they're intimidated to think that they're going to be retaliated against if they do. And so you need to have a way to promptly report it. Now, there's a lot of companies that in their HR policies or their safety rules say if you have an accident, if you have an injury as a result, a work-related injury, you must immediately report that incident. OSHA took that during the Obama administration, took it and said, well, no, you don't have to do it immediately, because that's too harsh on employers, and you kind of retaliate them if they don't do it right away. So you need to have, it should say, you need to report all injuries and illnesses, work-related injuries and illness, as soon as reasonably possible, but no later than 2 hours, 4 hours, 8 hours, end of the shift, however you want to do it. But that's the language you need to have in your things. And if you must report all injuries, work-related injuries immediately. You need to change that in your policy, please, because they're going to revert back to the Obama administration stuff on that. So, all right. So, once again, so here it says this is what's in the standard, record keeper standard. You must establish a reasonable procedure for employees to report work-related injuries and illness promptly and accurately. A procedure is not reasonable if it would deter or discourage an unreasonable employee from accurately reporting a work-related injury and illness. See, that's where they dive into the retaliation portion of it there. Maintaining incentive programs where you reward employees for having no recordable injury and illnesses. That is, OSHA considers that a discouragement, discouraging people from reporting. Therefore, if somebody reports it and they suffer some type of on the incentive program, and they don't get the gift card or whatever they're giving away, or a group of people don't get the gift card because one person reported a work-related injury under the incentive program. Well, guess what? The irony of the whole thing is the person reporting the injury is the one that has the ability to file a retaliation claim. The others don't. So, but anyway, you need to make sure you need to recognize there. So. Okay, and also they're going to be looking at, here's some of the memos here, and you should be able to pull this up on the OSHA website. These two memos are very instructive. They're really good information about how you got to handle these things here, but about post-drug testing, post-incident drug testing, and safety incentives, okay? So I would point to this. Once again, the idea should be a drug testing policy should limit post-testing to situations in which employees' drug use is likely to have contributed. What they said in here, or reading on employee not specifically suspect drug use before, but there should be a reasonable possibility that drug use by the reporting employee was contributing factor to the reported injury illness. They pointed to and how they were pointing to this, and if you read the preamble on this thing, and how they did this, they said, well, if an employee is working outside and gets a bee sting, obviously that's not drug related, okay? And if it gets a bee sting, it has a negative reaction, and that's considered an injury on the job, okay? A work-related injury, and they're recordable. So they were saying, well, just because I have a bee sting, obviously it's not drug related, so you shouldn't be considering that. So, and that's kind of reasonable. I understand that what they're kind of saying that. So, okay. So once again, the central inquiry would be whether the employee had a reasonable basis for believing that drug use by the report could have contributed to injury and illness. That's really that boils down this whole test to what you need to be recognizing there. So anyway, okay, what other steps do we need to be doing? Well, obviously, we want to make sure the OSHA poster, the OSHA poster that they have now, if you have that posted, it's going to protect you because it was written to cover the retaliation provisions and the notification provisions of the record keeping standards. So if you have the poster posted, that's going to help you a whole lot on that way. So, and as I mentioned before, do not say report immediately. You report as soon as reasonably possible, but no later than X time. So, you know, and move away from incentivizing lagging indicators, i.e. injury and illness data. So, all right. So, record keeping. Now, the record keeping's been there. I mean, it was spelled out in the Act in 1970. What they wanted, Congress wanted the OSHA to do was to collect data here on injuries and illnesses, so that it could help try to improve the overall safety. Is really what to do. So, when we're recording and reporting work-related injury fatalities, does that mean the employee was at fault? Also, and look at that last one, OSHA injury and OSHA record keeping are independent of each other. I mentioned that earlier. Because you have a workers' comp case does not mean that it's going to be recordable under OSHA's record keeping standard, okay? Now, like I said before, if the opposite, the flip side is probably true though. If you have an OSHA injury recordable, that's recorded, then it's a good chance it's going to be a workers' comp case. So. All right, so remember I talked about some partial exemptions here. If you were partially exempt because of your size or the type of industry, I remember I mentioned the 80 industries right there at the bottom, Appendix A, lists the 80 industries that are exempt. That does mean, or if you're under 10 or less employees, then you still have to report fatalities, inpatient hospitalization, amputation, loss of life. You have to do that. You have to do the annual surveys. You have to do the logs and the 300-day summaries if OSHA asks you to do it. And you'll get a letter. You would probably be getting a letter. You would have gotten a letter for this year. You would have probably gotten a letter in October saying, we want you to start collecting this data. The same thing with BLS, Bureau of Labor Statistics. They send out letters because the people that are in industries that are now exempt and they don't have to keep the data, they'll say, for the next year, we are requesting that you've been chosen. You need to keep the data for the next year. So you have to do those things. So, all right. So 10 or fewer employees, we mentioned that. Look at this, though. The 10 or fewer size exemption is based on the number of employees for the entire company, not just one location. And you're included. You also include your temporary employees who you supervise on a daily basis. We talked a little bit about that. All right. Who is responsible to record injury? Employees who actually supervise the employees are the ones that have to do it. And just remember what I said, the temporary employee providers, generally, there are some that do provide supervisors, but for the vast majority do not. And for those ones that you're supervising, they go in your logs. Make it that. And OSHA, this is one thing I think you're going to see focused on. It was focused on the Obama administration on this last bullet, where they were trying to look and see, were these people who OSHA employers were claiming to be independent contractors were actually employees, and then what they were doing was they were reporting that the OSHA inspectors would report that to their supervisors, and the supervisors would then contact the wage hour division in their region, and the wage hour people would come out and check this out. So because that was considered a referral, and they would do that. So I suspect you're going to see the same thing in the Biden administration. I'm sorry. So if you need to look, if you got people that have been working for you for 20 years, and you've been saying that they're independent contractors, you better look close at that. Especially if you're supervising them, you're providing them the materials or whatever things like that. They're probably not. You don't open yourself up to a big wage hour lawsuit. So, all right. So here's what we got to do. We got to try when we're going to determine if we're going to record these things. We got to look: is this work related? Is it a new case? Does it meet one of the criteria? And we're going to do a 5-step process. And here's the 5-step process. Every one of these questions, we have to answer yes. If we answer no at any one of these things, then it doesn't go on the logs, okay? It's not recordable. So we're going to go over each one of these areas. So look at this discussion of an injury to be an abnormal condition. Look how broad it is. It includes case but not limited cuts, fractures, sprains, amputation, illnesses, acute chronic illnesses, not limited skin disease, respiratory. So this is a very broad definition of what is an abnormal condition, all right? And then work-relatedness. Once again, I said about the presumption of work-relatedness is presumed for workers for injury and illnesses. That is the standard right there, 1904.5. It's presumed to be work-related if and only if the event exposure in the work environment is a discernible cause to the injury, illness, or a significant aggravation to a pre-existing condition. During the COVID stuff, this kind of went out the window for a while, but now it's kind of back. It's not 100%, but there's more and more presumption that it's going to be, if it occurs at work, it was work-related. Obviously, in the COVID-19, if somebody got COVID, it wasn't necessarily that they got it at work. So in a lot of cases, it wasn't that way. So anyway, let's keep. Work environment is defined as establishment or location where one or more employees are working are present as a condition of employment. And it doesn't mean a physical location. It can't be, let's look at Verizon. They got their trucks all over the place going out there. Amazon, all those groups have those truck drivers and everything. But all those people out there, they're not at a set location. They're going from place to place. But that's still the work environment. So you need to recognize that. Work-related. Oops, I went the wrong way. Okay, all right. Is an injury now work-related? Well, there's the presumption that it is, but there are exceptions. Or if you're a member of the general public, not work-related. Symptoms arising in work environment are solely due to non-work-related events or exposure, not work-related. Voluntary participation in wellness programs, medical, fitness, and recreation, not work-related. Eating, drinking, or preparing foods or drink for personal consumption, not work-related. Personal tasks outside assigned working hours, not work-related. Personal groom, self-medication, or intentionally self-inflicted injuries, not work-related. Motor vehicles, accidents in parking lots or access roads during commute are not work-related. Now, let me talk about this. I want to show you how this kicks in. Joe's driving his car. He's in the park. You got a big old parking lot here. He's in the company has a big parking lot. He's driving around trying to find a space, and unfortunately, Joe left the house a little bit late. And all the front parking spaces where he likes to park are now covered. So he's driving around fine and driving up and down the aisles there looking for it. And he's driving and he sees on the next row over, he sees a parking space. So he speeds up. Well, unbeknownst to Joe, there's also another person who sees the same space on the opposite side of the row. And they're both speeding, and they come around turn to go down the aisleway, and they collide, hit each other, and Joe gets injured. That's not work-related because he's not stopped. Now, if Joe gets to a parking lot and gets to his parking space, and it's been snow and ice out the night before, okay? So he gets to his spot. He gets out. He parks the car. He gets out. And as he gets out of the door, he stands up, and he slips on the ice, twists his ankle, and he goes. Now, that is work-related, okay? That would be work-related because he stopped his car, he parked in the parking lot. Now he's now considered at work. Now, Joe goes across the street. He finds out there's no darn parking spaces. He just can't believe this, but there's no parking spaces. But he can go across. There's a public parking lot, and you can get, on a day charge, it's not so bad, okay? But it's open air, and there's nothing, it's open air, so, so he gets out there, goes over there, and he parks his car, gets out of the car, and there's ice there, and he slips and twists his ankle in the public parking lot. That is not work-related because he's not on the company property. So you see that's why all these things, you got to be a little bit careful about how it works there. Cold and common flu, not work-related, but the pandemic was, so we need it, but you got to look at the OSHA guidance to be able to do that. Mental illness, provides opinion, is normally not work-related. Travel status. This is another one that I like to talk a little bit about. But an injury occurred on employees on travel. So you got a lot of people that are traveling to their job. Well, if they're traveling, they're driving their car or whatever. Now we'll look down here at the bottom a little bit. We'll talk about it in a second here. But they're driving in their car, and they get in an accident and they're injured. That's still work-related because they're doing the work for the company. Once they establish away from home, once they get to the hotel, park the car, and go inside, now they have established a home away from home. So now, if they get injured inside the hotel, that's not work-related, all right? Detour for personal reasons is not work-related. Now, this is my favorite example, so listen up. As you know, I live here in Atlanta. I'm in Atlanta, so Joe, I forgot to tell you about Joe. Joe is the Titleist representative here in Atlanta. And so he is driving He's going down to the Masters in 3 weeks, which is in 2 or 3 weeks. I can't remember. Anyway, the Masters is coming up. But anyway, in our example is he's going to the Masters. It's going to start in a couple of days. But he's the Titleist guy, and he has to set up his booth and everything. So he's driving from Atlanta on I-20 East, going towards Augusta, where the Masters is. 2 exits. He's almost into Augusta. 2 exits out. He sees a sign, and it says the Laurel and Hardy Museum. This exit. And he said, I love Laurel and Hardy. I'm going to get off on this exit and go see the Laurel and Hardy Museum. I got time. I don't have to be there. The thing doesn't start for another 3 days. So he gets on there, gets to the top of the thing. He's so excited about it. He's not paying attention. And it comes to a stoplight, and he's so excited. He turns left, goes through the stoplight, turns left, and doesn't see the oncoming traffic coming and hits and gets in an accident and gets injured. That is not work-related, because once he took the exit there, and that became personal reasons, and that's not work-related. All right? Now, Joe had continued onward and got down to Bobby Jones Parkway, which is 2 exits down. He would have, and got off there and got to the top of the thing and pulled out and got hit and got injured. That would still be work-related, because he's still on travel status. So just again, that. So, and of course, if you're outside the United States, it's not recordable. So don't even worry about that stuff. At home, we've had a lot of it there. OSHA's always kind of shied away from being on the home thing. So, but I would say this, that, if it occurs while you're performing work for paying compensation, you got your office set up there. You're doing a lot, and there's a lot of people obviously working at home now, or had been. More people coming back. But anyway, if you got up and you got out of your chair and you're getting ready, you're going to go in to get a cup of coffee or get a glass of water or something, and you trip over the circuit breaker cord for your computer, and you trip and twist your ankle, that would probably be a work-related injury. So, however, if you got up and you stepped on one of your children's toys, then that and injured your foot, that would not be work-related. So, but as a general rule, she's not exactly excited about looking into all that stuff there. Is this a new case? That's the next thing. Now we've done a work-related. Now we've got to go to a new case. Is this a new case? Well, if there's a medical opinion that says it, then you're going to follow the medical opinion. Always remember that if doctor says this, and that ties into a couple different things. But if an exposure is triggered by triggers a reoccurrence, then that would be a new case, such as asthma or rashes. But if the symptoms or signs reoccur in the absence of an exposure, i.e. tuberculosis, asbestos, whatever those things there, then that's not going to be a new case. And therefore, if it shows up and it was work-related 2 years ago, then you go back, and if the other person is having time off again, you go back 2 years and change the numbers 2 years ago. All right? So that's how we got to know that stuff. All right, then we next done is meet one of the general criteria. And here's some of these are the general criteria. Was there a death? Was there a day away from work? Was there restricted work activity? Was there transfer to another job? Was there medical treatment beyond first aid? Was there a loss of consciousness? Or was there a significant injury or illness diagnosis? If it is one of those, then it's going to more likely be work-related, it's going to be recordable, okay? Days away from work. Obviously, a fatality, if it's work-related, it's going to be recordable, period, all right? Days away from work, and what you do, if you have that where somebody is work-related and they're off, you do not count the first day. If Joe gets injured on the job on Wednesday, let's just talk about Wednesday here. He got injured on Wednesday, and he comes back on Monday. So how many days do we write down 4 days away from work? Well, first we're going to check the one box, and I'll show you that when we get to the forms itself. But then you start counting, but you do not count the day the person gets injured, nor the day the person comes back, okay? So he gets injured on Wednesday. He's out Thursday, Friday, Saturday, Sunday. Let's see that. Thursday, Friday, Saturday, Sunday. Right, and comes back Monday. How many days do we put on the days away from work? 4. Thursday, Friday, Saturday, and Sunday. You count all the days. You count weekends, you count holidays, you count vacation days. It doesn't matter. But you don't count the first day it happens, and you don't count when they come back. So that's that. So, and you go up. You see, I covered that. You stop at 180 days. This was a change back. trying to remember, was it Clinton or Bush 2? I'm trying to, I mean, Bush, it might have been Bush 1, excuse me. It might have been Bush 1. Anyway, they started adding all these. It used to be you only counted days they actually worked. So weekends, holidays, none of those vacation days, they weren't counted. Then OSHA changed the rule and said, no, it's going to be all going to be counted, but you can cut it off at 180 days. Either 180 days lost days away from work or restricted work. It doesn't really matter. That total, and I'll remember that. Always remember the total of both days away from work and restricted work or job transfer cannot exceed 180 days. You stop at that. But let's be honest about this. How often do you ever get to 180 days? Not very much. So it was, OSHA was saying they were trying to pretend they were doing the employers a big favor, but they weren't not. Now you can stop counting the days when the employee leaves the company for any reason unrelated to the injury. And a medical opinion exists, you must follow that. Remember, I had said that before. If Joe comes back, Joe gets a doctor's release from the doctor, and he says Joe can come back. Let's see, today's Tuesday. He can come back on Thursday. Well, Thursday comes. Joe says, I'm not feeling well. I'm going to come back on Friday. Well, you're still only counting. If he's off today, he only would have 1 day because the doctor said he could come back on Thursday, even though he didn't come back on Friday. Now, if the doctor says Joe can come back on Wednesday, and he doesn't come back, the doctor says Joe can come back on Friday, but just on Wednesday, he gets up Wednesday and says, yeah, I'm pretty good, I'm going to work. Well, guess what? You still got to put down Wednesday, Thursday, 2 days, because the doctor said he couldn't come back till Friday. You got to follow that. So just remember that. Restricted work, once again, if it's restricted work, you check the box, and I'm going to show you that on the form. Once again, you don't count the first day, the day it actually happens. Restricted work, look at this definition. Restricted work, unable to work the full day he or she would otherwise have been scheduled to work, or unable to perform one or more routine job functions. So what's a routine job function? Employee's routine job functions are those activities the employer regularly performs at least once per week. How broad is that? It's hugely broad. So just remember that. So restricted work, you're not recordable. It's not recordable for restricted work if it's just minor musculoskeletal discomfort, or if the healthcare professional determines that she or she's fully able to return to work for his or her routine job function. Once again, that's why you want to get the doctor's certificate. Or the employee is assigned to work restrictions for the purpose of preventing a more serious condition from developing. So those are the things so that's not going to be considered restricted work cases, and therefore wouldn't be recordable. So job transfers, an injured person is assigned a job other than his or her regular job for part of the day. I don't know why that dash is in there. I've tried to take that out several times. It wants to go away. For a regular part of it, other than his regular, any part of the day. Case is recorded if the injury owner performs his or her routine job function, job duties for part of the day, and assigned to another job for the rest of the day. So, all right. Medical treatment. Here's what we really want to get into, because this is really, most of the time when you're going to record something, it's because they had medical treatment. So, but look at this. It does not include, medical treatment does not include, and this is very important. You got to look at this because this is where a lot of employers make mistakes. Does not include visits to the healthcare solely for obstetric counseling, diagnostic procedures, first aid. Oops. Oh, here we go. Use of non-prescription medication or non-prescription tetanus immunization, cleaning or flushing or soaking of wounds, coverings, bandage stay strips, hot roll therapy, non-rigid support, temporary immunization. These are all first aid. If it's first aid, you do not record it, okay? It's not medical treatment. Drilling of fingernails, draining fluid, eye patches, removing foreign bodies for use of irrigation or contrast, first aid. Don't have to do it. Removing splinters from eyes by irrigation tweezers, cotton stuff, finger guide, massages. Now this one we got to look at, massages. Note, active release techniques, ART, is considered first aid. There is a fine line, and this is very important. There is a fine line between massages and physical therapy. If it's physical therapy, that's medical treatment, that's recordable. Massages are not recordable. It's considered first aid. So remember all that. and drinking fluids to relieve heat stress is first aid, not medical treatment. If a person has an accident and loses consciousness, all right, it goes on the log. Sorry, I don't care if he jumps up 2 seconds later. If he loses consciousness, it's recordable. Significant diagnosis, cancer, irreversible diseases, fracture, bone tract, punctured eardrum, all these things. If it's work-related, then it always goes on the thing. Bloodborne pathogen, this is a little bit more flexibility you have to be here, because if you have a needle stick, or if you get blood getting on an open wound, and that's what you really kind of have to look at there. If you have a needle stick, well, obviously it's going into your skin. If you have blood splattering and it goes into a sore or a cut in your hand, that would probably be more likely going to be recordable. So let's see, medical removal. We only have a couple standards, lead being the most prominent one, where employees are removed because of their blood lead levels and stuff like that. So if you're removing somebody because of their blood lead levels or whatever, their levels are being medically removed because of that, then that would be recordable, and you would record those cases there. Once again, if it's a voluntary removal to keep it below the level, if you're trying to keep it below the blood lead level, then that would not be a medical removal and therefore not recordable. So hearing loss, there's always this question about hearing loss, and you can see here you get to have a 10 decibel shift at the 22,000, 3,000, 4,000 levels. Then you're going to have to, from a baseline audiogram, then you're going to have to, that's going to be recordable. Now, let me tell you something. You have, and you got, let's see, wait, I want to go this one next. Yeah. What most people do, and this is what I tell all my clients to do, if you have someone shift, if you have a threshold shift off of the baseline on the most recent audiogram, then you got 30 days. You can redo the testing. Now, one thing you need to be looking at is that last where is it there? Oh, yeah, the second bullet. You can adjust for age. You go to Appendix F on 1910.95. The older you are, OSHA recognizes you're going to have some hearing loss. Therefore, you get credit. Okay, so look where you get the credit there. But normally, what you want to do, because most of the audiograms are conducted on trailers. They got these guys. The trucks come in. Everybody goes in, gets their hearing tested while the truck is there. If you have a shift, then I always tell my clients you should put it on a log, and then we may take it off based on what we're going to do. We're going to wait 30 days, and then we're going to have them go to the hearing doctor, the otologist, and have them tested in their office with much more sophisticated equipment, much more quiet. We're going to make sure that they're not doing anything loud noises the night before, and have them get tested there. You may find out that you may not have had a shift. So I find that probably half the time there is no shift, because it just, the equipment in the truck is not as good as the equipment in the office. So anyway, tuberculosis, it will get on the line if the employee is exposed to someone with known case. This is more of a healthcare issue, but can be. Look at here, but if you're living, it's not recordable. If you're living with somebody in your household that has TB, the health department identifies that a worker had contact with an individual with active disease outside of work. This is kind of like the COVID-19. They were looking on that type of same thing. So anyway. All right, so now we're at the forms. Now let's look at these forms very carefully, because I want you to understand exactly how you got to fill these things out. Look at that. Let's go. You see at the top there, or not at the top, where it says identify the person right now. A, B, C, D, E, F, G, H, I, J, K, L, M, 1, 2, 3, 4, 5, 6. All right, all the way across. You see that? We're going from left to right. On A, some people put 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Some put the workers' comp number, but then you may not have a workers' comp number. So you can have your own system. It doesn't matter. Then you got the name of the employee. Okay, going from left to right now. Job title, date of injury, all these things, it's where the event occurred. Remember, loading dock, north end, whatever. You want to have specific, and remember what I said. Hey, you notice if everything's happening if we're having all our injuries in the loading dock, we got to go look at that loading dock. What's going on out there? Then F, describe the injury, parts of body affected, and what directly injured the person. Look at the example. 2nd-degree burn on right forearm from acetylene torch. You cannot say cut to left hand. That don't cut it. You need to say cut to second finger on left hand from using box cutter. Has to be do that. So that's you got, and OSHA cites that for you. If you don't have enough detail in it, they're gonna cite you for it. All right, let's go to G. Look at this, GHIJ. This kind of the shaded area. You are going to check one of those boxes, and they going from left to right, from G to J. They are in order of priority. So, but you're only going to check one of these boxes. You're not going to check more than one, even if more than one applies. If you have a fatality, a work-related fatality, you check G, and that's it. Now you're going to go over to K and L. Maybe you may have lost work days, you may have restricted work days or transfer, whatever. But you're not going to only check. If it's only days from work, but you don't have a fatality, but you have days away, you're going to check H. You don't have days away from work, but you have restricted work, you're going to check I. If you don't have I, then if you don't have any one of those three, then you're going to check J, which is all. But this box, one of these boxes has to be checked, but only one of the boxes checked. Now going from K and L, these are going to put down the days away from work. You're going to put the number of days there, and then on the next under L, you're going to put down the number of job transfers or restrictions, the number of days there. Now remember, K and L cannot add up beyond 180 days. Do not go beyond 100 days. When that number is added all the way up, okay? And then when you go to M, once again, you notice they're shaded there? That means you're only checking one of these boxes. Most of the time, you're going to mark M1 for injuries. Maybe 2, skin diseases, 3, respiratory conditions. Hearing loss is 5. I can't see 4. And all others is 6. Now, OSHA during the Obama administration was talking about adding a 7th column that said musculoskeletal disorders, but that never went anywhere. So we'll see if that comes back during the Biden administration. So anyway, that's how you feel. All right, this is the 301s. If you're using the first report of injury form, your state workers' comp first report of injury in lieu of the 301, that is okay, but you must make sure that you see all these questions they ask you. You better make sure that the answers to those questions are on your first report of injury form. If not, then you need to add it. Okay, and we have one of these for every entry on our 300 log. We have a 301. Okay, this is the one that's very important. You need to. OSHA loves to cite this one here. Now notice here, this is the 301A summary, which we posted. We posted on February 1st and keep it up until April 30th. So, but look at that. Do you see that there under number of cases, GHIJ? Hey, where did I see those letters before? On the 300 logs. This is such an easy to form fill out because you're just taking the numbers, you total up the numbers at the end of the year at the bottom of each page. And if you have multiple pages, then you just total them all up until you get the final numbers. And then you plug in those numbers right there, okay? That's easy. That's really easy, all right? So then we go over here on the right-hand side. We got to put year 2020 is what we should have out posted right now. Name of the establishment, the street, city address. Then we're going to have probably our NAICS code there, North American Industrial Classification. You should probably be putting that there. Well, you need to put it there so you know that. Then you're going to put the average number of employees that you have at the establishment. Now, just remember, you could have more than one establishment. If they're not in close proximity, then you should have a separate. If you have multiple plants, each one of those plants is going to have its own 300 logs and 300A summaries. Okay. Then we're going to do total number of employees, and this is how many people are at that plant. That includes staff, workers, everybody, management. It doesn't matter. And then total number of hours worked. Now, the hourly employees, you'll probably be able to figure out pretty easily what the hours were. For the management people and supervisors and all that stuff, you got to guess. Sorry, but that's what you got to give a good guess there. And at the bottom there, look, there's a place for a signature. I certify and examine this document. Uh-oh. You know, if you're signing a government document, you better be careful about that. So there are only 4 people, and this is where OSHA gets a lot of people. There's a lot of employers. I get this all the time from my clients. There are only 4 people that can sign this document. Officer of the company, the owner of the company, the highest ranking official at the site, or the supervisor of the highest ranking official at the site. Those are the only 4 people that can sign this thing. If you're a safety person or you're an HR person, guess what? More than likely, you're not one of those 4 people. And a lot of times I have to get my clients to them to say, oh, you got the wrong person signing. You got to get the right person to sign above and date that. Don't change it. Don't change it. But just sign above. Now you're correcting it just so you know that you get the right person there. Get it right next year. All right? And remember, don't throw these away. You got to keep them for 5 years. Please do that. So let's keep going. Okay. We got to fill in the stuff. Oh, we have to fill in the entries on the 300 lives within 7 calendar days. All right? So we got to be doing that. So we can keep, as I mentioned, we keep on the computer, at the main office or whatever, as long as we have access to it. You can get that quickly to the things. Privacy protection. This is something we have a few privacy cases are, there's certain things that people can fall under that. Privacy case, injury to imminent bodily or reproductive system, injury and illness resulting in sexual assault, mental illness, HIV infections, hepatitis B, needle sticks, and if the employee voluntarily requests that his name be kept off of it. So what you would have instead with the name of the person, you would put privacy case. And you would keep a separate log locked up somewhere which had the name of the person corresponding to that particular number on the 300 logs, okay? But you also make sure that if there's only one person in the department, you're going to have to say not a privacy case and not list what department, okay? So there are exceptions here, but that doesn't come up very often at all. So, okay, let's see. Oh, if you have this is more for construction, but you may have this situation here. You have to have a separate 300 log for every establishment expect to be in operation for more than a year. So if a construction company, if you have a project that's going to go beyond a year, you do the 300 logs. But if you have, say you have 10 projects and they're all only 6 to 8 months long, then you can put all those on your corporate headquarters log, okay? And once again, but we have to have, every employee has to be linked to one establishment, and that's where that person's injury goes on. There is an exception to that when you got, if you got a person that comes out of corporate, his corporate is where he normally is, but he goes to one of the company's facilities and he gets injured there at the facility, that's going to go on that particular facility's log. So who's covered? Employees on payroll, employees who are not on our payroll, i.e. temporary employees who we supervise on a day-to-day basis. Self-employees and partners are not included. Temporary health agency. Remember what I told you about the temps. Put them on your log. Unless they're sending you a supervisor, they're going on your log. So I've already told you. Here's those 4 people that can sign the 300A. Right there it is. Okay. Post from February 1st to April 30th. We've already talked about that. We got to retain them for 5 years, plus the current year. We update the 300 forms, but when we update, it says there's nothing that says in the statute that you need to update the 300 days or the 301. 301 you're probably not going to need to update anyway. But the 300 days, if you update the 300, then you better go ahead and update the 300 days, all right? Because the numbers are wrong, and OSHA has cited employers for not doing that, okay? Employees are allowed to get a copy of the 300 by next business day. 301's next business day if it's the employee or their personal representative. Authorized representatives, like unions and stuff, get 7 days. So state plans, for the most part, all the state plans are the same. It's really, there's so little difference, it's hard to tell. So, okay. I've already talked about this. Reporting, remember, there's a difference between reporting and recording. We record stuff on the 300 logs. We report fatalities, hospitalization, amputation, loss of eye to OSHA. That's reporting. Everybody has to report work-related fatalities, hospitalization, amputation, loss of eye. Okay. Now, we do not have to report highway or public street motor vehicle accidents. Okay, unless it's in a construction zone, and then it's because they're probably construction people. So, do not need to report do not have to report commercial airplane, train, subway, bus accidents either. Now, but look at this here. Do not need to report. Okay, report. That doesn't mean they don't go on the 300. They still go on. If you have a person gets hit on the highway and has a fatality, you don't have to call that in. But it does go on your log because it's a work related. They're assuming they're doing earned travel status. Same thing with all those things. You don't report it, but you still record it. All right. Must be recovered copies to the government resident within 4 hours. And we're here at the end of the way. So, and I think we got 5 minutes. Hold here, 5 minutes to answer any questions. But once again, I just want to say thank you for your commitment to safety. So it's right. And look at this. Remember, bad decisions make good stories and usually make the evening news. So we really need to be a little bit careful about that. So, and that's just the kind of disclaimer. And there's my information. If for some reason you need to get a hold of me, if you have any questions, if you want to get extra copies of the PowerPoint or the a record-keeping worksheet, be more free to email me, and I'll be more than happy to send it. So, Anna, do we have any questions?
We do have a couple questions.
All right.
Our first one is, just to be clear, do you have to report it if a fatality happens and it is not work-related? Or do you have to report it and prove it's not work-related?
Now, you have to make the determination. Now, that's a good question, just to clarify. If it is not work-related, then it's not recordable and it's not reportable, okay? Let's remember that. Now, heart attacks, OSHA takes the position, and I kind of disagree with that. They say in the statute if you have a heart attack, you should contact OSHA, you should call it in, and OSHA will make the determination if it's work-related. Well, but it's your job to make the determination it's work-related. It's just like that case that we had the person I had told you that died at his desk in the evening. He was not doing anything strenuous. He was just doing his regular job, and he just died. He had a bad heart. He had problems with his heart anyway. He'd had heart problems before, so it clearly was not work-related. We didn't call in. Now OSHA found out about it, and they threatened to issue a citation. I said, well, look, it's not work-related. You show me they showed me that there was some type of exertion or something that caused him to die that made it work-related. And they couldn't, and they didn't, and they dropped it. I had one other case that they had issued a citation where we didn't report it, but they ended up dropping it because it clearly wasn't work-related. So some people want to go ahead and call everything in because they're just afraid of OSHA. My feeling is you make the determination, is this really work-related or not? If it's not work-related, that's that. Now, if you have a stroke, if it's a stroke, there's nothing in the statute that says you have to report a stroke, even though it's a fatality. It may have here, but they don't. But they do give a portion of it that talks about heart attacks. And so, but once again, if it's not work-related, it's not recordable nor reportable.
Okay, our second question is, I know if your workers' compensation EMR is over 1.25, I believe that OSHA comes in to complete an audit. Is that correct? And can you talk a little bit more on that?
Well, they have what they call site-specific targeting programs, and they just announced that they were going to go back to doing those site-specific targetings, which are based on DART rates and injury and illness rates. That doesn't mean you're going to have an inspection. It doesn't really mean that. There's other things. They just did a new emphasis. They just started up a new national emphasis program that's connected with COVID. They're looking at those cases there. They've identified state-divided industries that are covered in that. But the site-specific targeting was intended to go after what they call the bad actors. I never liked it. When I said of OSHA, I didn't like that term. I thought it was a little disingenuous. Who knows who's a bad actor? Somebody may have, some numbers may comp up. Let me tell you something right now. With this COVID-19 and all the numbers that we reported and the people that were out because of COVID-19, they could have the best safety program in the world, and their numbers are shooting through the roof. They're having a DART rate of 10. That doesn't mean they have a bad safety record. And it's going to be interesting to see what OSHA does with respect to site-specific targeting on those type of things, because they're going to have all these companies that have these whose injury and illness rates and DART rates have just shot out the roof because of COVID, and because they got COVID-19, and then they stayed out for 10 days. Well, let me tell you, you stay out for 10 days, 14 days, whatever it is, or if you get sick and you're out longer than that. Holy smokes, your numbers are going to look crappy. You're going to look like you have the worst safety program in the country. But you don't. And OSHA's going to have to try to figure out how to address that, to be quite honest. I just don't know how because it doesn't mean they have, the whole purpose of site-specific targeting was to try to go after what they considered the bad actors, people that had really high injury and illness start rates, and because they've obviously had bad safety issues. And that makes sense, but, so we'll see, because they said they're going to start up the site-specific targeting now, so we'll see what goes on.
Okay, our next question is, if an injury goes over to another year, do I stop the count on December and then start the count in January?
No, just keep adding it on to the one in December. It's not a new case. You have a new log, so it's not a new case. It's an old case, and it's all based on that injury there. So you want to have a record. What OSHA wants to see is a record of, on that injury, how many days did that person miss, and how many restricted days or transfers did they have. So no, you keep recording. If you have something that occurred in December 2020, and now we're in March and they're still out, those numbers are still going. They're still going back on the December one last year.
And then we have 2 more questions. Do you want to answer them now, or did you want to do it through email?
We're good.
Okay, perfect.
We're good. We might as well finish up.
The next one is, if you need to update the 300 log for some reason, when are you able to do so if you can?
Well, you're supposed to update whatever it is. You have 7 days to put an entry on the log, on the 300 log, okay? Somebody gets injured, you have 7 days to get on the log. Now, you're supposed to monitor them. There's no specific date, but at least I think on an annual basis, you're supposed to monitor them and determine, if somebody's out, somebody gets injured and they're out, and but they got seriously injured, and they're not going to come back for several months. You normally just do a guess. If you go to the doctor and ask them how long do you think you'll be before they're able to return to work, to full time to their job, and you get an estimate, and you put the estimate down. When they finally come back, you should be updating that and checking to see exactly how many days did they actually miss and clarify that. It may be more, it may be less, but you should make sure that that number reflects that. If it's less, you definitely want to show it. Less is better, because the less you got, your DART rate, injury and illness rates are going to keep it down. So that's why it's important to do it that way.
And our last question is, if an employee hurt themselves, is the employer liable to give the employee a case number to seek medical attention?
That's a state issue. Most states, most states will allow an employer to say, here, you got to go to our doctor, okay? But it also allows them to go to the employee to pick their own doctor to go to, so they can go to that. And if the 2 doctors disagree, then the employer normally will appoint a 3rd doctor to be a tiebreaker to give a thing like that. So, but as a general rule, it's a workers' comp question of what your particular state allows on that. But normally, the employer gets to pick a doctor to go to, and then the employee has the ability to go seek another opinion from his or her own doctor.
All right. I think those are all of our questions today. Ed, thank you so much for going overtime to answer those for us.
Happy to do it. Thank you again. Thank you for your commitment to